Welcome back to Exhibit A-List, where pop culture gets cross-examined. I'm your host, Jasmine Weg. I'm a lawyer, and today we have a packed one. Jill Zarin got fired from Real Housewives of New York reboot before filming even started, and what happened to her could happen to anyone with a job and a phone. Zillow is facing class action lawsuit accusing them of secretly steering homebuyers toward their own mortgage products. That lawyer who lost his case using AI quotes and Fahrenheit 451 to the judge, Anthropic just launched a legal AI plugin that sent the legal industry stocks into freefall. And France is mailing fertility reminder letters to every single 29-year-old in the country. And people have thoughts. So some quick housekeeping. You can find me on Instagram, Jasmine Weg ESQ, and the podcast at Exhibit A-List Pod, and you can find me on TikTok at Jazz the Lawyer. This episode hits for you. The best thing you can do is follow the podcast, leave a rating or review, and please send it to someone who needs to hear this. Let's go. So last week I told you that the original Real Housewives of New York cast was leaving Bravo for a new show on E called The Golden Life. This week, there's already an update, and it's a good one for the legal breakdown. Jill Zarin, who is 62 years old and an original cast member, a fan favorite, was fired from the project on February 10th. Yeah, right after the Super Bowl, before a single frame was shot. And the reason matters because it's not just a celebrity story, it's a story about something that could potentially affect you. Now, here's what happened. As the entire world knows, Bad Bunny performed at the Super Bowl halftime show on February 9th. Reviews were divided. People loved it, and some people had issues with it. Well, Jill came online and posted a video. I think it was a live, so it was later deleted or automatically removed. But as we know, on the internet, things can stay forever. So someone probably screenshot it. But the video was criticizing the performance for being in Spanish, and she commented on the lack of white performers. There was a lot of backlash, and it was fast. Now, Blink 49 Studios, which is the production company behind the show, announced the next day that they were cutting ties with Jill Zarin. She was fired. Zarin Fabrics, which is the company her late husband Bobby founded, also put out its own statement distancing itself from her comments, saying that she hasn't been associated with their company in several years. Jill said that she took down the video immediately. She said that she wasn't given a chance to respond before the decision was made, and that might be completely true. But here's the legal reality anyway. It doesn't really matter. Here's the thing about morality clauses, and this is the part I want you to actually absorb, because most people don't know that these exist in their own contracts. In entertainment contracts, and honestly, even a lot of corporate employment contracts, there's language that gives a company a right to terminate you if you do or say something that they believe damages their brand. The language is intentionally broad. It doesn't say that you have to commit a crime. It says things like conduct that is offensive or objectionable to a reasonable person, or it might say like statements that are inconsistent with the values of the company. And so it's very, very wide net. And here's why this is important for you. Because you need to understand the world that we're currently living in. Taking something down does not unsee it. The moment something is posted, it exists permanently. Screenshots travel faster than deletions. By the time you hit delete, someone may have already saved it and someone had already sent it somewhere. In 2026, there is no version of I took it down that fully puts the toothpaste back in the tube. Now, for a balanced approach here, there is a legitimate conversation to be had about whether the pace of these decisions has gotten too fast. Jill went from posting a video to losing a job in less than 24 hours. There was no conversation, no context, and she seems like she didn't have an opportunity to explain herself or apologize or retract. And depending on your perspective, that could either feel like appropriate accountability, or it could feel like a world where one post can erase everything else about you. And both of these reactions are understandable. But the law does not require a company to give you that conversation. If you are a contractor, a cast member, a talent, and your contract has a morality clause, they can exercise it, and they don't owe you a phone call first. So the practical takeaway here is that, and this is me talking to you as your lawyer bestie, before you post anything, ask yourself whether you would be comfortable if your employer or your clients or a production company saw it. Not because you should self-censor everything that you believe. It's because what you post publicly is now part of your professional identity, whether you want it to be or not. And that's just the world. So the golden life is going to continue with Ramona, Luann, Sonia, and Kelly unless and until someone else says something that gets them scrapped. Are you guys going to be watching? Because I'm kind of intrigued. Now, raise your hand if you've used Zillow to look for a home or an apartment, or if you've just been nosy and looking at what someone else's house looks like. But the answer is everyone. Everyone uses Zillow, which is why this lawsuit matters. Zillow is facing a consolidated class action lawsuit in Washington federal court alleging that it pressured real estate agents to steer home buyers towards Zillow Home Loans, Zillow's own mortgage product, in violation of a federal law called RESPA, the Real Estate Settlement Procedures Act. And if the allegations are true, then the company that you trusted to help you find your home was also quietly working to make money off your mortgage without you knowing it. Here's how it allegedly worked. Zillow has two programs for real estate agents, Premier Agent and Flex. That gives agents access to buyer leads. In a world where finding clients is one of the hardest parts about being a real estate agent, access to those leads is extremely valuable. We're talking about their entire livelihood. According to the lawsuit, Zillow used that leverage. Agents in the Flex program were allegedly told that if they didn't meet referral quotas, meaning they had to send a certain number of clients to Zillow Home Loans, then they risked losing access to their leads entirely. So the deal on the table was keep getting clients from us, but in return, push your buyers toward our mortgage product. Now, just hearing that, I know that just sounds funky. This is allegedly the illegal part. RESPA exists specifically to prevent this. The law prohibits kickbacks and undisclosed fee splitting arrangements in real estate transactions because those arrangements harm buyers. The whole point is that when your agent recommends a mortgage lender, they should be recommending the best option for you to help you get the best rate, not the option that protects their access to leads. The plaintiffs in this case are real home buyers who say that they were steered towards Zillow Home Loans and ended up with higher interest rates and fees than they would have gotten if their agent had been free to recommend independently. And here's the part that should land. If you paid even a quarter point higher interest rate on your mortgage because of this, then over a 30-year loan, that could be tens of thousands of dollars out of your pocket. In December 2025, a Washington federal judge consolidated two separate lawsuits against Zillow, Taylor v. Zillow and Armstrong v. Zillow, which is funny because Taylor Armstrong, Real Housewives, hello, what a tie-in for today, into one single case. Zillow has denied any wrongdoing, as they should, because if you're, how else are you going to defend yourself in this? And they say that their programs comply with all applicable law. The broader issue here is one I want you to think about. Zillow started as a search tool. Then they got into mortgages because that's how businesses work. Once you get a really strong hold in one side of things, you're like, why don't I start making money off of this other related area? They started buying and selling homes directly. When one company has a financial stake in every stage of your home buying experience, the question of whose interests they're actually serving gets complicated. And most people using Zillow have no idea that dynamic even exists. I feel like this is probably happening a lot in the real estate world. I remember when I was buying my home, my real estate agent knew the seller's agent, and the seller's agent and my real estate agent both kind of made a recommendation about a home inspector to me. I went with it. It was my first time buying a home, and I didn't really think twice about it. But what was interesting is when I was there for the inspection, I really sensed a closeness amongst the agents and the inspector. Lo and behold, the inspector turned up zero issues with the home, actually kept referencing the prior time he had inspected this home. I had no idea that he inspected it the last time it was sold, and it did feel a little funny. I remember after having moved into the house, I did see a few things that I knew should have turned up on the inspection report, especially because when I was in talks about another home, I had used another inspector on that home, and it was a much more comprehensive report. So you do see that when different players are working together, like the agent, the inspector, the broker, etc., the mortgage broker, they are all hoping to keep giving each other business. So it makes you question whose best interest do they have in mind? And you wonder, is it the home buyer? Okay, now I need you to focus for this one because it's a lot and it's kind of interesting and it's kind of weird. On February 5th, Judge the Southern District of New York entered a default judgment against a company called Affable Avenue LLC. Now, default judgment means that they automatically lost their case, and this was not because of the merits, it was because of their lawyer. And here's what happened step by step because this lawyer kind of screwed up royally. Affable Avenue was being sued for trademark infringement. Their attorney used AI to help draft their legal briefs. And the problem, and this is the problem that keeps happening when people are using AI in their legal practice, is that AI hallucinates. When you ask an AI to find cases that support a legal argument, it will sometimes just invent them. You can actually ask, like, did you make that up? And they will respond, well, yes, I made that up. Now let me find some real ones for you. It's weird. So in this case, the AI cited cases that didn't exist, and it might attribute quotes to real cases that never said those things. And if you don't verify every single citation, especially pulled from AI, before you file it with a federal court, you're going to have a very bad day. In this case, opposing counsel flagged at least 13 cases in this guy's briefs that either did not exist at all or existed but did not contain the quotes he had attributed to them. 8 additional cases reportedly existed, but the quotes were completely fabricated. The judge issued an order asking this lawyer to explain himself. And instead of saying, I'm so sorry I used AI without verifying, here are corrected papers, like own up and then accept full responsibility, which would have been painful but survivable, this guy submitted a response that the judge described as noteworthy for its conspicuously florid prose. I don't think that's a good response. The response included an extended quote from Bradbury's Fahrenheit 451. There were metaphors about gardening. One line talked about leaving indelible marks upon the clay. Like, what are you talking about, bro? The judge noted that this response looked stylistically completely different from this guy's other filings, the ones with grammatical errors and run on sentences. So, guess what? The judge said this response was AI generated too. This guy used AI to argue his way out of using AI. He used AI to respond to sanctions for using AI. This is so meta. I love it, honestly. And then he lied. He emailed opposing counsel claiming that he had already notified the court and filed corrected papers, but he had not done those things. The judge said that the extraordinary sanction of default judgment, meaning like it's extraordinary because the judge is ultimately punishing the party, the client, who didn't really make these mistakes, and it really sucks for that client. That client had to automatically lose their case. But the judge said it was warranted because this was not one mistake. It was a pattern. Repeated false citations over months, lying about fixing it, failing to comply with the court orders. This guy just couldn't be stopped. He was like obsessed with AI. His client lost their entire case because their lawyer couldn't be bothered to verify what an AI told them. So, like, I know that people are going to listen to this and think, oh my God, this is why AI is dangerous. And if you're of an older generation, you're probably very hesitant and scared to even use AI. But listen, you just have to use this as a learning curve. You just have to use this as a lesson. It's not so simple that AI is dangerous. The tool is not the problem. It's known that AI hallucinations are real. AI hallucination citations are a known issue. Every legal professional, if you use these tools, you should know that you have to just verify every single output before you file it anywhere. That's not extra credit. That's basically professional responsibility. It's already taking a lot of the work out of your day for you. It's already cutting your time. You don't even want to spend the time to verify that what it's selling you is true. Then that's on you, not the AI. The problem with this lawyer is that he used a tool that he probably just didn't understand, probably didn't know that it hallucinates. He probably was like, wow, I found a miracle. I can just crank out papers in 2 minutes. And then when he got caught, he compounded every single mistake with more mistakes instead of just owning it. And in general and in life, when you do make a mistake, the best approach is just to own it and just start fixing it from there, because digging yourself deeper rarely ever is the solution. And the Fahrenheit 451 thing, I cannot let this go without noting the irony. Fahrenheit 451 is a book about a dystopian society where books are burned and information is controlled. He quoted a book about the destruction of written knowledge in a response where he had fabricated written citations. If that was intentional, it's kind of brilliant, but I think at this point, his AI was sabotaging him. His AI was probably like sick of seeing this guy and like, oh, you're coming back again? I'm going to screw up your apology note. The lesson here for lawyers and for anyone using AI professionally, which at this point may be all of us, is that you are responsible for every word that goes out under your name. The tool does not share professional liability. You can't add them on your policy for insurance. So you have to verify everything. And that pairs perfectly with what we just talked about. And that leads me straight into my next AI topic because Anthropic, which is the company that makes the Claude AI model, just launched a legal plugin for their platform earlier this month. It automates contract review, NDA triage, compliance workflows, legal briefings, and templated responses. So this is crazy because it's essentially doing the daily work of first and second year associates at a law firm. And it's doing the big law stuff, the kind of stuff that people are paying $1,200 an hour plus to these top law firms to do for them. The market reacted immediately. Like everybody is up in arms about this new legal plugin. Thomson Reuters, who owns Westlaw, dropped about 16% in a single day. The parent company of LexisNexis dropped 14%. These are huge companies. These single day drops in the market mean that this legal plugin is a huge threat. And what else is crazy is the billable hour model that powers BigLaw and has powered it for decades basically works like this. You hire junior associates and they do document review and contract drafting and research, and you bill clients by the hour. And that work generates revenue, a lot of revenue. But if AI can now do that work faster and at a fraction of the cost, and corporate clients who have been pushing back on billable hours for years, they're going to start to demand to pay for outputs rather than hours. You can't just say, oh, this should take 10 hours if it took 2 minutes through AI. The math stops working. Now, Anthropic is very clear that all outputs from the legal plugin do have to be reviewed by a licensed attorney. Thank God they put that in because you know that guy from the previous story was never going to review it. You would have to knock him over the head with that legal disclaimer. But they're not claiming that it replaces lawyers, but hello, it's cutting down the legal billing time for sure. The practical reality is if one lawyer with AI can do the work that used to take 5 junior associates, you're going to need fewer junior associates. And that's going to have consequences for people graduating law school right now. There's a genuinely good side to this that I don't want to dismiss. AI legal tools could make legal services more accessible to people who can't afford to pay hundreds of dollars an hour for a lawyer to review their lease or their employment contract. The access gap is real and it's a problem. If AI helps close it, that's great. The question is, are people at home going to rely too much on the legal plugin versus ever consulting with an attorney and then just trusting that everything they're doing on their own with AI is following the law, not knowing about all the hallucinations, not knowing that it can misinterpret things? That could be dangerous too. The story we just talked about is the cautionary story of the same coin. These tools are powerful, but they have real limitations, and the people using them just need to understand both. But this disruption is happening whether the legal industry is ready for it or not. And you know what? I'm a lawyer, but I'm here for it. I like to see things get shaken up. I want to see how our profession adapts. And now let's talk about France mailing out fertility letters. So France has a plan to address the falling birth rate. The plan involves mailing a letter to every single person turning 29 in the country and reminding them that their fertility is declining and encouraging them to consider freezing their eggs. Let me give you a moment to just sit with that. Okay, here's the background. France's birth rate has dropped to about 1.56 children per woman. You need 2.1 to maintain a stable population. In 2025, France recorded more deaths than births for the first time since World War II. So the government introduced a 16-point national fertility plan, and one of those points is this letter campaign. They're targeting 29-year-olds, specifically because in France, women can freeze their eggs at 29 without a prescription. And France's social security system covers egg freezing for women between 29 and 37. So the government is essentially saying, we're paying for something you might not know exists. Here's information. Guys, imagine your 29th birthday in the mail next to that card from grandma with a check for $10 is a letter from your country saying, girl, those eggs are getting stale. Oh my God. The letter is going to go to everyone turning 29 regardless of gender, with the acknowledgement that men also experience age-related fertility decline, just on a different timeline. France's health minister has been clear that the goal is not to pressure anyone into having children. Sure, but she framed it as a public health information campaign, making sure that people have the information that they need to make their own choices without later saying, if I only had known. And I think the reaction to this is genuinely interesting because it splits very cleanly along a fault line that tells you a lot about how people think about government and bodily autonomy. So, on one side, this is a reasonable public health campaign. Fertility does decline with age. That's medically true. Egg freezing is expensive in most countries, and many people don't know that their government will pay for it. Informing people about available options isn't coercion in any sense. But on the other hand, a lot of 29-year-olds, particularly women, are finding the letter patronizing. The experience of the government showing up in your mailbox to say, it's a reminder your clock is ticking when you're just simply trying to live your life, maybe build a career, figure out who you are, it's just not landing as neutral information for everyone. Not everyone at 29 children or even thinks about children. Not everyone has found a partner. Not everyone is in a position financially or emotionally to be thinking about this. And receiving that letter from your government when you did not ask for it lands differently for different people. From a purely legal standpoint, this is within the government's authority. It's an informational campaign. No one is being required to do anything. The legal issues would only arise if France just started restricting or mandating reproductive choices, which is not what's happening here. But the line between public health information and government commentary on your personal life choices is one that a lot of people draw in different places. What I find interesting is that declining birth rates are a policy challenge in countries all over the world right now. Hungary, Russia, South Korea, Japan, and governments keep trying different levers to address it. Financial incentives, parental leave, child care subsidies, and apparently now letters, which is crazy because in America, I have not heard that we have this birth rate issue, but we definitely have issues with parents not having access to those things while they are parents. Parental leave, child care subsidies, financial incentives. We, as parents, would love, and we are having the babies here. I'm just saying our government could take some notes. What almost none of these have fully grappled with, though, is that a lot of young people, for them, the issue isn't information or even desire. It's that the economic conditions required to feel ready to have children, which include stable housing, financial security, affordable childcare, are becoming increasingly out of reach. So, a letter just acknowledging your fertility and its steady decline is not addressing the issues. Well, the court is now in session. Welcome to Petty Court, where the stakes are low, the feelings are high, and I am the only judge that matters. Today's case is the statute of limitations on spoilers. Here are the facts. Suits ended in 2019. Someone is now in 2026 watching it for the first time. Oh, to be you. They're on season 4. They mention it in the group chat. Another person in the group chat immediately responds with, oh my God, I love Suits. Okay, wait until you see what happens with Mike in season 5, and then proceeds to describe the major plot twist in full. Now, the person watching it is, of course, furious. The spoiler person says, the show is 7 years old, bro. That's on you. Counsel, present your arguments. Now, the defense would argue 7 years is more than sufficient time for the general public to have watched a show. There is no reasonable expectation of a spoiler-free window after 7 years. Personal scheduling is not other people's responsibility, but the plaintiff's going to argue, I told you, in real time and in this exact conversation that I had not seen it yet. You had live information and you chose to proceed anyway. Now, here's my ruling. The 7-year rule is real. In general conversation, you are not obligated to tiptoe around a show that ended 7 years ago. The window has closed. However, the 7-year rule contains one exception, and it is this. When someone explicitly tells you in real time that they are actively watching and have not yet reached the spoiler point, that disclosure resets the clock for that conversation. You now have actual knowledge that they have not seen it. Proceeding to spoil it anyway is not protected by the rule. The rule only protects you when you didn't know. If you knew, you knew. Verdict: the spoiler is guilty of aggravated inconsideration. But guys, be mindful of the statute of limitations, okay? Don't go around expecting no one in the world to spoil the show for you. Your sentence is one episode's worth of snacks delivered in person with a formal apology that does not include the phrase, "It's not that serious." Court is adjourned. Well, that's episode 19. Jill Zarin got fired before filming started, and it's a lesson for all of us with jobs and with phones. Zillow allegedly ran a kickback scheme that may have cost homebuyers some real money. A lawyer lost his entire client's case using AI, and then he used some more AI to try to get out of it. Anthropic's legal plugin is making BigLaw super scared, and France is sending fertility letters to 29-year-olds, and the takes are all over the place. Guys, please come find me and tell me which story got to you. DM me on Instagram, Jasmine Weg ESQ, Exhibit A List Pod, TikTok, I'm Jazz the Lawyer. If you haven't followed yet, please do it now. If you have a second to leave a rating or a review, it makes a real difference for how people find the show. And if someone in your life needs to hear any of this, please send it to them. I'll see you next time on Exhibit A List. Stay curious.